All right. Thank you very much. Good morning once again. Today we'll be focusing on study unit 1, which is the requirements of the legal requirements for a civil marriage. What is a civil marriage? A civil marriage, it is firstly monogamous, and it is entered into by two opposite sex, meaning a man and a female, male and female. And it is heterosexual, it is voluntarily, and it excludes other people. Please note that an engagement, it's not a requirement to a civil marriage. So we're going to enter into addressing the legal requirements for a marriage, a civil marriage. Somebody's mic is on, and I'm finding it difficult to proceed.
Stephen.
Students, I'm sorry about that. I see that our mics, for some reason, they all muted ourselves. I've been busy talking. I've just realized now that my mic was off. Mulebogeng, I think your mic is also off. Mulebogeng, can you hear me?
Oh my goodness.
Yes, I've been talking. I've been saying, please unmute yourself. Then I started taking over. Only to realize that my mic was also off. Okay. I'm sorry about that, students.
All right, sorry. I'm very sorry. Okay, so I need to start from the beginning, right?
No, you can just start with the requirements because you had already said something about civil marriage.
Okay, thank you very much. Thank you for noting that down. We okay. The requirements include capacity to act. And there's a certain group of people who the capacity to act is actually limited, or it's more, I would say, maybe other people need to confirm their capacity to act. In this case, we're speaking about minor children. The children below the age of 7 years have no capacity at all to enter into a civil marriage. The children between the age of 7 and 18 have limited capacity. to enter into a civil marriage. According to Section 26 of the Marriage Act, boys below the age of 18 and girls below the age of 50 need consent of the Minister of Home Affairs. And above all, they also need the consent of their parent or legal guardian. Section 24A of the Marriage Act states that a civil marriage entered into by a minor child without the necessary consent is not void, but may, on application, be dissolved by a court. So we're going to go to the second group of people, which are the declared prodigals. These people can enter into a civil marriage without a curator's consent. Okay? A declared prodigal is someone who cannot run their own affairs, so they need a curator to manage their matters. So in this case, they can enter into a civil marriage without the curator's consent. Somebody's mic is on.
Okay, Mulebach, I'm sorry to disturb you. I'll keep on checking those mics who are on. Students are saying on the comments that they cannot hear you. Do you mind just raising your voice?
Okay. Can they hear me now?
Yeah, I can hear you. But before you continue, let's just hear what Likona wants to say. Likona Shakani, Likona, you can unmute yourself.
Thank you, ma'am. Good morning, team and colleagues. I just want to ask Lebu to repeat what she said regarding the age of 18 years in terms of consent, because I think I only have 12 to 14 years, 12 years for girls and 14 years for boys that needed a consent to supplement their limited capacity. Now, what is he saying about the 16 to 18? Mentioned something about the consent. I just need to get that. Yes, sorry.
Okay, students, can you please reserve the questions for later, if that's okay?
No problem.
Because we have limited time, so we're trying to cover up everything that we can within this limited time that we have. So if you have questions, please note them down and we will tackle them when we're done with the session. Is that okay with everybody?
Yes, apologies.
Can everyone hear me then?
Yes, I can hear you, ma'am.
Okay, thank you very much. Can you, if you can hear me, just send the thumbs up icon so I know that you can hear me.
Okay, students, I'm going to mute everybody. Please unmute yourself immediately because other students are refusing to mute themselves. So I'm going to mute now, and then before you start talking, please just unmute yourself. Okay, get that.
Okay. All right, thank you very much. Let's proceed. At the second group of, okay, we did the second group of people, of person. Then we're going to the third group of persons who the capacity to act is actually a concern, which are the mentally ill persons. Somebody's mic is just bothering me. Okay, let me proceed. The mentally ill persons can only enter into a civil marriage during a lucidum interbellum. And the fourth group of persons who may enter into a marriage are persons under the curatorship due to a disability or a chronic illness. This person can enter into a civil marriage without the consent of a curator. Understood? Yes, I did mention that the curator is someone who runs the affairs of someone who cannot run their own affairs. Okay, moving along, the second requirement is the agreement. In other words, the concern. Can you hear me? Someone saying my line is not clear. Solufelo. Okay, let's proceed. In terms of the agreement, in other words, the consent, it is a requirement, it's a legal requirement to a civil marriage. An agreement means that the two persons entering into this marriage must agree, they must have consensus into entering into this civil marriage. However, there are factors which can have an effect on the agreement. The first one is the mistake. Mistake can come in this case in two ways. It can be a mistake concerning an identity of the party, meaning that you might be thinking that you're marrying someone who is, for example, who says she is taller in a certain age, and you agreed because of the certain the length or the tallness of the person, and then it happens that if there was a mistake, that person is actually shorter. So you agreed to the marriage because of the certain identity of the person. So such can have an effect on the consensus, the agreement of the marriage. The second mistake is the concern in the nature of a juristic act, which is a form of a material mistake in such a civil marriage. The second factor is the misrepresentation, meaning that one would have agreed to the marriage under a misrepresentation, being misled by the other party, where the other party is not truthful in a statement that they gave, or gives a false impression to the other party to agree to the marriage. The third factor is the duress. Duress is actually when a spouse is being forced to consent. In this particular factor, we have the case of Smith versus Smith. I think those who have their textbook can see it in page 25 of your textbook, page number 3.3.4. It actually states the case and where the jurors has been identified. And then the fourth, okay, let me just read out the what the case said. In this case, the father and the husband forced this the lady to enter into, the wife to enter into this marriage forcefully, like forced her to consent to the marriage, and later the court concluded that the jurors rendered a marriage voidable, therefore the marriage was set aside. Okay, and the fourth factor, which is undue influence. In this case, the parties involved entered into have been persuaded or being influenced as a result. So the marriage entered into by the party, it can either be one party or both parties have been influenced into entering into this. So the agreement or the consensus has been influenced in this case. So the effect of the validity of such marriages that have had the effect on the consensus. Firstly, when the marriage is entered into and a mistake has been identified, it is unclear whether the marriage is void or voidable. So when the marriage entered into with the effect of a misrepresentation to the agreement has been identified, the marriage is then voidable. When the marriage entered into under duress of the agreement to the marriage is then voidable. when the marriage under undue influence is being entered into, the marriage is voidable. This is also you'll also find it in, I think, in study unit 2. So that one you don't have to worry much about it at this stage. We're also going to continue with it in study unit 2. So the third legal requirement for a civil marriage is lawfulness. In this case, we are going to look at whether the marriage entered into is lawful. There are certain relationships that will make the civil marriage to be unlawful. So there are groups of relationship, or I would say, yes, persons that would conclude the marriage to be unlawful. So if you see on your study guide, page 6, there is a structure in which it explains how there's a, I would say, yes, a structure that shows how these marriages would go around, how the relationship would be. So we have the consanguinity, which is the blood relationship, and we have affinity relationship, which is the which is a relationship by marriage. So we're first going to tackle the consanguinity relationship, which is the relationship by blood relationship. So when one gets into a relationship, or maybe into a marriage, one cannot get into a marriage by consanguinity through a direct line. Direct line meaning that you cannot get married when you share maybe parents and when you share kids, or when you have when you share kids. The second line is the collateral line, which is where your brothers, including your brothers, sisters, nephews, and nieces and cousins, those people cannot get married to each other. And when we look at the affinity of marriage, which is the relationship by marriage, the direct line includes your parents-in-law and your spouse's children from a former marriage, meaning your stepchildren, and so forth. So those people cannot get married. The affinity marriage in the collateral line, meaning your sister-in-law and your brother-in-law. So those are the limitations that lawfulness has on the civil marriages. So if you go down on the structure on page 6, it actually shows you who is your descendant and who is your ascendant, so that you have an idea. This map gives you an idea on which marriage is lawful and which marriage is not lawful. Okay, then we're going to move. Okay, let me just read out this for you guys so that you have an idea of what I'm talking about. There are 4 rules. So the consanguinity rule, the consanguinity relationship, whereby blood relationships or relatives in the direct line may not marry each other. One may not marry any member of his descendant or ascendant. Blood relative in the collateral line may not marry each other if they are related in the common ancestor in the first degree, meaning the first generation of the relationship. One may not marry their siblings or their children or their grandchildren. Note that one may marry their cousin as the relationship in the second degree, the common ancestor being their great grandparent. In affinity, that is the marriage by that's the relationship by marriage. A person related to one another through affinity in the direct line may not marry each other. One is not allowed to marry a blood family through the direct line of his or her spouse. I think that one is clear. And then a person related to each other by affinity in the collateral line may marry each other. So meaning that one may marry their sister-in-law, their brother-in-law, their cousins, their nieces, their nephews, and of their spouses. That's the difference. Okay. And we're going to move to prescribed formalities, which are needed in entering into a marriage. Okay. Okay. In the prescribed formalities, firstly, there must be a marriage officer, and the marriage officer must be an authorized marriage officer who solemnizes and prohibits, is an authorized officer who solemnizes a prohibited civil marriage. So a marriage officer firstly must be an authorized one, because there is a possibility that you might go to someone who's not authorized to solemnize your marriage, and your marriage becomes invalid. So firstly, the prescribed, the authorized marriage officer, and all magistrates such as justice of peace and commissioners can also assist in being marriage officers. The Minister of Home Affairs may also appoint other persons as marriage officers. Such persons may include officer in the public, diplomatic, and consular. And the minister of the religion, or anyone holding a responsible position in a religion, dominion, an organization for the purpose of solemnizing marriages in accordance with a Christian, Jewish, Muslim, or Indian religious rites. So in South Africa, I wrote this, okay, a person who has been appointed as a marriage officer outside of the borders of the Republic may only solemnize a civil marriage if both parties are South African citizens and are domiciled in South Africa. So no one can perform a marriage without being appointed, duly appointed as a marriage officer by the Minister of Home Affairs. And then the second thing we need to focus especially on the prescribed formalities is the formalities where we proceed in the marriage ceremony. Well, there is a form of way, or I would say process, that takes place, especially when during the proceeding of a marriage ceremony. So in this case, one can also raise an objection when entering into who is against maybe the taking place of the civil marriage, and that person must always give their grounds, and the marriage officer must inquire into those grounds on which the obligation is based, and may only solemnize the marriage if they are satisfied that there is no lawful impediment into the marriage. So there's also need to be a identification document or a prescribed affidavit to proceed with the marriage ceremony. The third formality is the formalities during the marriage. Well, the Marriage Act requires that both parties must be personally present at the solemnization of the civil marriage. Thus, no one can conclude a civil marriage without the presence of each party. Or maybe one cannot even give proxy to stand on behalf of another party to the marriage. So these parties, both of them, need to be present. And the civil marriage, there's a time and week in which the marriage can be, well, the marriage can be done in any time, but the marriage officer is only obliged to civilize the marriage at any time, either than in any time between 8 a.m. and 4 p.m., which means 800 hours and 1600 hours. So there's a case here on your textbook in page 31, 3.5.3 in ex parte do, whereby the husband had applied for alignment of his civil marriage on the grounds that it has been solemnized in the garden of a private dwelling of a house and not in the house as required by section 29 subsection 2 of the Act. However, in this case, the court concluded that the objection of this provision have been to avoid clandestine marriages, which is meaning that it's the provision that had previously served in the form of the public of an intended civil marriage and has been abolished. All right. So in all marriage ceremonies, the prescribed formula must be adhered to. The marriage officer must put the following questions between the parties separately, whether they agree to the conditions of the marriage, whether they are there voluntarily, like meeting all the legal requirements to a civil marriage, and also whether they agree to marry that very specific person. Remember, we spoke about that mistaken identity. Yes. And the last requirement the last legal requirement to a civil marriage is the registration of the civil marriage. The marriage officer may solemnize a civil marriage. The parties thereto and the two contented witnesses must sign the marriage register immediately after the wedding. The marriage officer then sends the marriage register to the regional or the district representatives of the Department of Home Affairs. Then a copy of the entry of the register serves as a prima facie proof that the marriage has been solemnized. Non-fulfillment of the registration requirement does not affect the validity of a marriage, and registration can be effective postnaturally. So which means if they found maybe a defect within the registration or the copies or any document therein, that can be resorted afterwards, after the registration of the marriage. Somebody's mic is on. Interview, you can move to the other slide. Okay, we came to the completion of today's session. We tackled the marriage, the legal requirements to a marriage, to a civil marriage. So anybody with questions related to the section 1 of the marriage? I'm studying unit 1 of the civil marriage. Can we see with the raise of hands any questions? Okay, let's just see a show of hands so that we have maybe we have a line maybe of people that we will ask questions, then we'll say so and so is after, so and so is after, and then we are okay with that.
Start with Likona again. Likona Sekane. Likona.
Thank you, ma'am, very much. Once again, I have jotted only 2 questions. Sorry for a point of correction, ma'am. Sorry, I have joined the team with my son's count. My name is Lonwabo Zegeli.
Okay.
Okay, my question, coming back to my question, I don't know if you have jotted my question before regarding the 16 to 18-year-old. Do they need consent to enter into a civil marriage? 8 years, that's question number one. Number two is, it is stated that whomever that is objecting or have an objection regarding the civil marriage, then one has to lodge that objection with the officer, with a marriage officer. I just want to find out how then one, and perhaps then I need to be educated, how then one would know of that wedding that will take place on that particular day, or how the other person who wants to object will know of this wedding, and then what is the duration of the objection, if then there is a time frame, because I'm under the impression that if I want to get married, we can, with my partner, wake up the following day and go to the magistrate and have that a marriage, whatever, like private marriage, so to speak. When will the other person who wants to object will be able to object? I know of that perhaps maybe Botswana is doing it very proper when they publicize over, I think, a couple of months, 30 days or more, so that one can be able to have that objection. That's a plenty of time. But in terms of South Africa, how then do we exercise such objections? If then it's not, if the marriage is not being conducted maybe in the church, and that particular person who wants to object have a privy to know that. In the case of magistrate, how then do we do that? Thank you.
Molebogeng, please unmute yourself. Molebogeng.
Sorry about that. Thank you, Likon. But you did mention that you're using someone's name on the Teams.
Yes.
Okay. No, it's fine. Thank you for your question. I'm trying actually to get you the.
Okay, while you're looking, Molebogeng, let me answer the second question, which talks about the duration. In South Africa, there is no specific, there is no time frame for objection during a civil marriage. Instead, that is done during the solemnization of the wedding. So civil marriages now can no longer be conducted at court. It can be conducted either by the marriage officers, which are priests, pastors, or they can be solemnized at the Department of Home Affairs. So if the parties go to Home Affairs, it becomes very difficult, because at the offices of Home Affairs, they just need the parties themselves and 2 witnesses. So if the marriage officer says, is there anybody who wants to object, and there is nobody to object, the marriage will continue. And another important thing that you should note regarding civil marriages is that once the marriage has been solemnized, the parties, including the marriage officer, they need to sign the marriage register. Hence, it is possible that, let's say, there is somebody who is married and goes and enters into another civil marriage, which, by the way, is unlawful because it's bigamy. Civil marriages, as Molebogeng said, are monogamous and can only be entered one time at a time between a man and a woman. But let's just say, for the purpose of answering this question, a man or a woman who's already married and then goes to Home Affairs, or let me say that party is married in he's in an unregistered customary marriage, and because the marriage is not registered, he decides to take the new partner, and then they go to the Department of Home Affairs and enter into a civil marriage. Because the existing unregistered customary marriage spouse is not aware of this civil marriage, taking place, they will not have an opportunity to actually object to the solemnization of the civil marriage. And after that, the marriage officer will actually go ahead and have the parties sign the marriage register. So under these circumstances, if a spouse enters into a civil marriage and all the legal processes have been followed, but that spouse is actually still in an existing unregistered customary marriage, the only solution or the only remedy that the customary marriage spouse has is by bringing a high court application to have the civil marriage declared null and void, because the spouse entered into that civil marriage while being in an existing customary marriage. But unfortunately, as I said, there will no longer be any opportunity to object, because the marriage would have been completely solemnized and the parties would have a marriage certificate.
Thank you.
Are you able to, are you answered on that?
Yes, ma'am. Thank you. I'm clear. The first question.
Okay.
Thank you very much.
The first question.
Okay. Likona, I don't know if you have your textbook with you. Do you?
Yes, I do have it, ma'am.
Okay. On page 17, Roman figure, I think 2 and 3. You asked where that is, ne? Where the capacity of the children to get married is, right?
Okay, here.
Do you see it?
Yes, I can see girls
All
between
right.
2
Yes. Okay. Are you answered it?
Yes, I'm answered.
Okay. All right. Thank you very much.
Okay, the second person whose hand is up is Mongesi. Mongesi, you can unmute yourself and ask your question.
Hello, ma'am.
Yes, Mongesi.
Yes. In terms of the Civil Marriages Act, I understand in the textbook and in the thingy, the study guide, it clearly states that it's a marriage between two people of the opposite sex. But my issue is here with the latest amendment happening in the country. Must we not maybe amend the textbook, because it is now accommodative of same-sex marriages and stuff like that? Thank you.
Okay, remember, as we'll be going with the sessions, we'll be talking about, or we'll be tackling different topics. Civil marriages are marriages which are still legally recognized, which are still in existence, and they will forever be in existence. Then we've got same-sex marriages, which are regulated by the Civil Union Act. Those marriages, again, are legally recognized, are in existence, and will forever existent. We are going to cover them separately. And there is again customary marriages. We are going to cover it separately. These are 3 different types of marriages that individuals can enter into, but they've got different requirements and different types of people can enter into them. For example, as Mulebeng said, civil marriages are monogamous, and you cannot take another spouse while you are you cannot take another spouse while you are in a civil marriage. They are monogamous, and secondly, they can only be entered into by a man and a woman, irrespective of their race. And then we've got same-sex marriages, which are entered into by spouses of the same sex. Then we've got customary marriages, which are entered into in terms of custom. And customary marriages, we're specifically speaking about those which are entered into by Black South Africans. And then we've got religious marriages. We'll be talking about Muslim marriages, and we'll be talking about Hindu marriages, which at the present moment are still not legally recognized, but there are certain legal rights which spouses actually get by being part of those marriages. So all these marriages, we have to talk about them separately because they've got legal requirements and then they are not the same. For now, we are concentrating on a civil marriage. So Kamogela, I see your hand is up, but before we can take your hand, I just want to understand, just one or two of you, when we talk about civil marriage, do you understand when somebody comes to you and says, you know what, me and my partner, we want to enter into a civil marriage? Will you be able to understand, okay, because of the different types of marriages that as we live in our society, we have heard about them, we have seen them on TVs and all of that. If somebody says, I want to enter into a civil marriage, will you be able to, do you understand what a civil marriage is? Students, you can just do your thumbs up to say, yes, if somebody just come and say, this is a civil marriage, I will be able to explain that. When we talk about civil marriage, we talk about this type of marriage. Do you understand, student, what a civil marriage is?
Yes, ma'am. Thank you very much.
Thank you so much. Now it's clear to me. I understand very well.
Oh, okay.
Thank you.
Okay.
Yes, I understand.
Okay, thank you for that, student. Kamogelo, you can unmute yourself and ask your question.
Okay, how are you, ma'am?
We are fine, Kamogelo.
Thank you.
Thank you very much. My question is actually based on study unit 3 on consortium omnis vitae. Am I right?
Study unit 3 or section 3, under
Study unit 3.
what? No, we are now dealing with study unit 1. We are gonna
Okay,
next week we're
so
gonna do study unit 2. So reserve that question for when we do study unit 3.
okay, no problem.
Okay.
Thank you very much.
You're welcome.
Okay, I'm just Mlivasa, I'm just looking at the comments here talking about same-sex marriages and all of that.
Okay, I see Sipati is.
Okay.
His hand is up. Sipati?
Yes, on prescribed book, 3.2.5, they're talking about the minor between the 7 and 18 years of age that have limited capacity to act. That also include regarding to get into the civil marriage, right? So as Mulebogan was starting to represent here, I noted some of the point that she was making. And then she said below the boy below the age of 18 years and then the girl below the age of 15 years, they need the consent from their parents or the guardian. Can I get the clarity on that?
Yes, they do. Sipati?
So, yes. So on the prescribed book 3.2.5, it's not only a between minor between 7 and 18. We have to separate if it is a boy or a girl between those ages.
Come again?
On 3.25, right? They only talk about the minor. They didn't explain if it is a boy or a girl, and they said between 7 and 18. And then on the point that I took.
Okay.
Hello?
Yes, continue.
Yes. And then you said a boy below the age of 18 years.
Yes.
And the girl below the age of 15 years. I'm a bit confused because of what the prescribed is saying and what also you make a point.
Okay. If you look at if you look at page 17 of your textbook, Roman figure 3.
Okay.
You see Roman figure 3 where it states that the Minister of Home Affairs.
The textbook or prescribed book?
The textbook is the prescribed textbook, not the study guide.
Okay, page 17.
Yes. Roman figure 3.
Yes.
Do you see that?
Yes.
Do you see the section where it states that the section 26, subsection 1 of the Marriage Act?
Oh, yes, yes,
All
yes.
right, there you go.
Now I can see that.
You're welcome.
Thank you.
You're very much welcome. Spelele.
Hi, ma'am.
How are you?
Hi. I'm
Yes,
good.
we
And
can
you?
hear you. You can, yes, you can ask your question.
Oh, okay. Okay, ma'am. I'm not sure whether you'll be able to answer it because it also consists of some section, but it's only declared prodigals. Since declared prodigals can marry according to Pinar versus Pinar's case, the declared prodigal can enter into a civil marriage since if he or she can manage her assets. So my question was that can is a declared prodigal enter into a community of property or out of community of property?
Okay. Do you see? Okay, let me show you on the. Do you have your textbook with you?
Yes, I do have it.
Okay, do you see page 14?
Page 14. Okay.
3.2.2.
Go there. Page 14, 3.2.2. Yes, I can see it.
Okay. It states that a person declared prodigal may not enter into a civil marriage without being obtained his or her curator's consent. If he or she does marry without such a consent, the civil marriage is out of community of property, according to the case.
Oh, okay. Okay.
Is your question answered?
No, I get it now.
All right. Thank you very much.
Yes, it is answered. Thank you.
All right.
Thanks a lot.
Stembiso, you can ask your question.
Good morning. So my question goes back to the civil marriage. You said that civil marriage can only be entered by two people, right? Now, say maybe for an example, the two parties are in separation, they are not divorced, and the other party wants to enter into another civil marriage or whatever marriage with another person, but they are not divorced. What happens in that case?
It is not possible for someone to get into a civil marriage without resolving the first civil marriage. So for the person to enter into another civil marriage, they need to divorce or terminate the first civil marriage.
Okay, thank you.
You're very much welcome. Pete, you can ask your question.
Morning.
Morning.
Basically, I just wanted to ask the previous student question. So, because I said, as I read here, it says that civil marriage is a lifelong voluntary union, right?
Yes.
So yeah, that's my question. The previous student has already asked the question that I wanted to ask.
All right. Thank you very much.
Thank you.
Okay, students, when you're done with asking your question, if your question has been answered, can you please raise your hands lower your hands icon so that we know that how many students we need to go to.
Okay, Mulabakhan, I just want to tell the student again that there is a common law criminal offense called bigamy. This is when a spouse who is in a civil marriage enters into another marriage without firstly dissolving their civil marriage. A civil marriage can only be dissolved through divorce or through death. Those are the only times that a civil marriage can be. So if there's a spouse who goes and enters into another civil marriage, then they are the spouse can go and lay a criminal charge for bigamy. Whether their spouse will be arrested is another story altogether. Understand? And the other thing that student needs to be made aware of. Okay, student. Okay. Another thing student needs to be made aware of is when Home Affairs registered the marriages, when Home Affairs, let me just move everybody. When Home Affairs registers the marriage certificates, it can only register per couple. So if you are in a civil marriage and you want to take another spouse, Home Affairs will not be able to register that marriage because there is already an existing marriage certificate on the system. So even at Home Affairs, they will make you aware that you need to bring a copy of your divorce decree for us to firstly update our records. And after we have updated our record, it is only then that we can register the subsequent marriage. And that record will only be updated if there is a valid divorce certificate, a valid divorce decree from court. Okay, thank you. Mulebogang, you can unmute yourself because I had muted everybody. Please unmute yourself, Mulebogang, so that we take questions.
Okay. I see Lerato Make. Lerato.
Good morning.
Morning. How are you?
Good, thanks. Ma'am, I'd like to know, someone asked a question about a prodigal person entering into a civil marriage. Ma'am, can you hear me?
Yes, I can.
Yes, I'd like to know what is a prodigal person? How are they declared prodigal?
Okay. Do you have, I don't know if you have your textbook. Well, a prodigal person is someone who cannot run their affairs, meaning that they cannot take care of themselves in the way that they need to take care of, meaning their finances, especially in certain decisions that they need to take. And then the court appoints a curator who assists that person in making such decision, especially in their finances, in their well-being, and so forth.
Okay.
Yes.
Thank you.
You're welcome. I don't know if Sipati wants to ask another question, or this is the time when she made her hand. If your questions have been answered, please remove the hand raised icon. Okay. Umbulani, you can ask your question.
Good morning, ma'am.
Morning, how are you?
I'm very good. And yourself?
Thank you very much.
I want you to go back to the question of the age differences between boy and girl. Because I think in our constitution, we do have constitution and also sections in terms of legislatures. But where our constitution and legislatures are not communicating one language, that section can be considered. Am I correct?
Okay, I want to understand what your question really is. Are you saying, what are you saying about the Constitution, and what are you saying about the provision in the Act?
In fact, the issue with me here is that when it comes to boy, the age is 18. And when it comes to girl, the age is 15. But in our constitution, all people are equal. So if by any chance we have question of that nature, how to respond to that?
Okay, if you can, do you have your textbook with you?
Yeah, page
Okay.
17.
Page 17,
Yeah.
Roman figure 3.
Yeah.
It states that as the age of majority is 18.
I can see that.
And then there is this is taken from, you see, there's a 39 there.
Yes. 39.
Yes, which means this is dated from the Child's Act.
Yeah.
So it says that the requirement in section 26 subsection 1 means that all minor children must obtain the consent of the minister. Remember, even in the Constitution, there is a limitation to certain laws in the Constitution. That's where legislation comes through.
Okay.
As much as they say it's 18, but there is a legislation that tries to make it fit in for other, like your question that you're giving now. It says the majority age is 18. However, the section in the Marriage Act allows the minor children to have consent from the minister.
From the minister?
Yes.
No, I think I agree now.
All right.
Thank you very much.
Laurentia?
So scan with a copy, and then after they scan after. So it's better also you speak as a copy, looking as a video scan.
Lucretia, can you?
Hello, ma'am. Can you hear me?
Yes, I can.
Ma'am, on the case of prodigal, I just want to know is does disability and autism part of it? Hello, ma'am.
Yes, I'm not really sure if it will fall under prodigal or mental persons. I'm not really sure. Ntabiseng, do you have an idea of where the group of persons she's talking about fall into?
Okay, I missed the question. What was the question?
I'm asking, ma'am, under prodigal, does disability and autism also fall under it? As some people with disabilities also cannot handle their own personal affairs and so on. So I just need clarity, and the same with autism, ma'am.
Okay. Politically, it has to be proved that the person must not be able to manage their own affairs. So if, let's say, there is somebody who has autism, but they are able to function, because I understand that the others are able to work, they're able to manage whatever little money that they are getting. So those ones cannot be declared as prejudicial. So it must be somebody who is disabled and unable to manage their own affairs. The fact that they are disabled or they have, the fact that they are disabled does not necessarily mean that they can be regarded as criticals and they need a curator to handle their own affairs. So remember, having autism again does not necessarily mean that a person is really unable to function. There are people who are not disabled, who do not have autism, but have to declare the prejudice because they cannot manage their own affairs.
Yes.
Do you understand?
Okay, ma'am. Okay. Thank you.
Okay. Okay, I'm seeing hands, but I don't know where you ended. This is gonna be our last 4 hands because I'm seeing 4 hands. So we'll start with Lucretia. Lucretia, are you the one who just asked a question now?
Yes, ma'am.
Yes.
Okay, you can put your hand down. Then there's Pelele. Has Pelele asked a question?
Yes, I think he did. I don't know if he's coming again with another question. Oh.
Okay, let's move on to.
Yes.
Okay.
Yeah. Okay. It's this same issue of this protocol now. I'm trying to understand something. We once argued with someone on our WhatsApp group about this thing that a declared protocol can enter into a civil marriage, and I said yes. Why? Because there's this thing that someone can enter into civil marriage without his or her curator consent if he or she actually has the capacity to act when married. So my question is, does the declared protocol has a capacity to act or no or not? So that it can be easy for me to identify whether he or she can enter into a civil marriage.
Spelele, do you have your study guide with you?
Hello.
Study guide, yes, I do have it.
Page 4.
Page 4. Okay, I'm there.
Yes, where it states the I think the first person, it says that they are the declared protocol. They say
The protocols.
yes, the effect of capacity
They can
to enter
enter.
into, yes, they can enter without.
Okay.
Yes.
All right. So protocol does have a capacity to act.
Yes, even without the curator's consent.
Curator's consent. All right. Thank you. Thanks a lot.
Thank you very much. Ngakampa, you can ask.
Hi, ma'am. How's it?
I'm good, thanks. And how are you?
Good. My question is concerning the consent of a minor to enter into a civil marriage. On the part of, like, in the absence of the consent by the parents or legal guardians, then I see that there is a Minister of Home Affairs and the presiding officer of the Children's Court. I want to know, in the absence of a consent by the parents or legal guardians, which one comes first? Where does a minor go for like to get a consent between the presiding officer of the Children's Court and the minister of the Home Affairs? Which one should be applied first? Thank you.
Okay, thank you for your question. I think you see on your textbook on page 17. Do you see that?
Where on page 17? Roman figure 2 or 3?
Yes, both of them. It states that the child, the minor, can actually go to the legal guardian, which is either the parent or the legal guardian. I mean the legal guardian. The legal guardian in this case can also be it must be a person who is fit and proper to actually take over as a legal guardian of this child, right? Okay. According to the Act of the Marriage Act, the Minister of Home Affairs is the one who can give consent to the minor. So it depends whether on the child, whether they find, they can also go to
what?
Mulebukhaim, please unmute yourself. You've just muted yourself.
Who also? Sorry, I think maybe just this case is very sensitive. If you see on the at the bottom there, it speaks about how the legal guardian also needs to obtain consent from the High Court. So the minor first, if they don't have consent from the, you say in the absence of the consent of the parents, they can either go to the legal guardian or the Minister of Home Affairs. However, the Act promotes the Minister of Home Affairs first. I would say first.
Okay. Then I'm
Yes.
answered.
Yes.
Before the presiding officer of the Children's Court, the Act accepts that the Minister of the Home Affairs must be the first to be granted those powers.
Okay, do you see at Roman figure 2, the part at the end where if the legal guardian has his or what to enter into a civil marriage, they must obtain consent from the High Court?
Yes.
Yes.
Okay.
So meaning they must also get permission from the High Court.
Okay. No, I get it. Thank you.
Thank you. And we have Jonia. I hope I'm saying right. Relebogile.
Good morning, everyone.
Morning.
I just want to ask a question. I don't know if it's irrelevant or I want to know the difference between a civil marriage and a civil union. Do they do the same process or is it different?
Ntabiseng, can you answer this question?
Okay, the difference between a civil union and a civil marriage is that a civil union can be entered into by same-sex marriages, but in terms of the Civil Union Act, people of the opposite sex can also enter into a marriage using the Civil Union Act. So John and Rose, if they want to enter into a marriage, they have an option of entering into a marriage using the Marriage Act, then enter into a civil marriage, or enter into a marriage using the Civil Union Act. And parties of the same sex can only enter using Civil Union Act only. But the legal sorry about that, but the legal requirements, the processes, they remain the same. The legal consequences, they remain the same. The only difference is for same-sex parties, they cannot enter into a marriage using the Marriage Act, but opposite partners can enter into a marriage using the Civil Union Act. That's the difference, but everything else remains the same.
So I wanna ask in terms of where it says if the other party has performed a reassignment of a surgery or treatment, do they enter? Is it possible for them to enter a civil marriage?
Okay, it depends what they identify themselves as now. Remember, our constitution says we must not discriminate. So if they identify themselves, let's say it's a man who now identifies and then has changed into be a female and then enters into a marriage with a man, then it's gonna be a woman and a man, and they want to enter into a civil marriage, then they can enter into a civil marriage because the record will be saying they are no longer a man, but they are now a woman.
Oh, okay. Thank you.
You understand?
Yeah, I do understand now.
Okay. Students, we have come to the end of our session. Thank you for attending, and apologies for all the technical challenges that we had today. We are hoping that as we are moving to the next sessions, things are going to be not really perfect, but they're going to be much better than the challenges that we had today. Please be on the lookout for our next communication, but we are going to have the next session next week during this time, 10 o'clock to 11 o'clock. Thank you for attending and have a good day ahead. Goodbye.
Goodbye, ma'am.
Goodbye. Thank
Bye-bye.
you.
Bye, ma'am.
Bye.
Goodbye.
Thank you. Bye.
Thank you, ma'am.
Thank you. Thank you.
Thank you.
Yeah,
Thank
madam,
you.
goodbye.